Good afternoon, everyone. This is South African Bar Association presentation. As you are aware, the South African Bar Association is a weekly event at no cost to participants and viewers to improve the skill set of the legal profession. This initiative is aimed at making a fundamental contribution to developing the skill set of all and any person who presents the South African public in our courts. It is my honor and privilege to introduce our eminent speaker today. Our speaker today is Advocate Aslam Bava SC, currently a member at the Tumanukwa Group. By way of providing a brief background of Advocate Aslam Bava, Advocate Bava, apart from being a renowned SC, he has been appointed to various panels and arbitration committees and basically has made a fundamental contribution in his career to the legal profession. To give you a few examples, on a voluntary basis, he has chaired the EFSA training division. He is a constitutional law expert. He is a renowned arbitrator and mediator. He is an expert in mediation law, to mention but a few of his successes. He is a member of the Shanghai 14. To his credit, he appears on behalf of a number of religious organizations on a pro-amico basis. Advocate Bava shall be continuing his previous address in a Part 2 session of Building a Successful Legal Practice. A few housekeeping matters. These sessions are recorded, and we appeal to participants to ensure that your microphones are muted and that your video cameras are switched off. Accordingly, during the address, all participants shall automatically be muted. If a participant has a question, simply raise your hand using the Microsoft Teams platform. During the question and answer session, please restrict questions to the speaker relative to the topic and only pose such question when called upon. Without any further ado, I now hand it over to Advocate Bava. Over to you, Advocate Bava.
Thank you very much, Ahmed. I wonder if you can see the presentation in front of you.
We can.
Okay, thank you very much. I'm now going to start my presentation, and good afternoon to each one of you. Firstly, as the last time, I must commend the South African Bar Association on ensuring that there is an element of continuity in terms of our education, and also that we start assisting and we continue assisting each other in building better lawyers, better advocates, and ultimately a better society. The first session that I had was a very conceptual element dealing with fundamental aspects relating to how we see the world and how the world sees us in terms of our practice. That is very crucial in terms of coming to terms with our capabilities, our limitations, and with fundamentally dealing with how we interact in the legal profession and as human beings. Today's session is going to take you to a different aspect. It's going to focus on the practicalities of how to develop a successful practice. So building a successful practice, this is part 2, and this is obviously presented by me, and those buildings are hoping that we will all reach those heights. So the first element is to have a paradigm shift. And this paradigm shift is, we're in a world where we want everything the same day or the next day, and we want it, just place an order online and it should be delivered to your door within 48 hours. Practice and building a practice is, fortunately, I would say, not like that. It is a marathon, and I think we need to pause there, and we need to mention that it is a marathon. It is not a sprint. And the reason for that is that you start developing certain skill sets, you start developing certain relationships, you start analyzing things from different perspectives because of your experience, and one block on the other, you create an environment that takes time. And so that is the first paradigm shift that you have to associate yourself with. You have to enter into this different paradigm, and you have to tell yourself it's not going to happen within a month, within 6 months, within a year, or within 3 years, or possibly even within 5 years where you want to see yourself. But each one of these are milestones. And as you go through these milestones, you need to appreciate each one of the milestones. You know, it is the same issue that when you are growing into anything, even as a human being, that you don't appreciate the times that you are in, and you seek to look at the future. And when you get to that point in the future, you start reminiscing and looking back and say, those were good days. I wish I was back there. So the idea is to enjoy every step of the process and to work on the paradigm shift and to make sure that you understand that this is a marathon, it is a process, and it is not just going to happen overnight. Your practice is made up of 3 components, in essence. Firstly, a professional service component. Secondly, a business component. And thirdly, an individual person component. So the professional component, we will deal with each one of these in turn. And the individual person component is actually you. Because if you are practicing as an advocate, it's wholly dependent on your presence, your being present in your practice. If you're not there, nothing will happen. So let's go to the first one, the professional service component. And this is very important, and these are practical things that you need to start looking at. So what is the professional service component that you have to have? And like any business, if you produce or provide good service, you will most likely get attorneys returning and clients returning to you. It's people wanting a service that is reliable, that is sustainable, and that they are secure in their minds that if they employ this sort of service, they will receive a certain type of an outcome. And so that is crucial. What are the components to this? And this is where we need to discuss. The first one, you'll see I've put in be punctual. Now, many people underestimate the element of punctuality. But punctuality tells you many things. It tells the attorney and it tells the client of what type of person they are dealing with. Is this person going to be able to produce goods within a time frame? And will this person act in our interest? And is this person somebody that we can rely on? Those are the elements of being punctual that just automatically appear in a person's mind. And you can just take an example. If somebody tells you they're going to meet you at a particular time and you sit waiting for the person, every minute seems like 10 minutes have gone by, and you keep on either looking at your watch or trying to call the person. Where are you? What has happened? Why are you not here? And so be on time for consultations. I cannot stress this enough. Being on time for consultations is crucial. Number one, your client is paying it. Number two, your attorney does not have to give an excuse to the client as to why you are late. So there's a saying, and I hold very close to this saying. It's rather be an hour early than 5 minutes late. Rather be an hour early than 5 minutes late. And it's a very good and very important principle to live by. And it's very important to be punctual for your consultations and then for delivering the products on time. So if your attorney requires and your client requires a pleading to be out in a particular time at a particular time, memorandum to be produced at a particular time, you need to be punctual and you need to meet those deadlines. And you will see as we go through that develops, and it allows you to develop a holistic and a very compact, but also a very efficient practice. Understand your brief. Now, this is perhaps a very, very important aspect, and one that people who start off a practice are normally afraid to ask an attorney because they are under the impression that the attorney, that by asking a question from the attorney regarding the brief, they do not want to appear as though they do not know what they are doing. So you need to rather engage with the attorney. So if the attorney gives you a brief X, Y, and Z, do X, Y, and Z, produce a memorandum, and you're not sure of the parameters of what needs to be done, engage with your attorney, ask questions, find out what is it that you want me to produce in this memorandum, and what is the purpose of this memorandum? How is it going to assist the client? And when you engage with your attorney at that level, and you understand your brief properly, you will produce the product and the memorandum that your attorney and client require. Otherwise, you may go on a different tangent, and you will most probably lose the attorney and the client. So it's no skin off your nose to actually go in and ask your attorney, I've received this brief, it says so, X, Y, and Z in the memorandum, let's chat about it, I'll call you, and let's discuss what I need to do. Then you need to have the necessary tools available to do the research. Now here I must tell you that it's becoming more and more obvious that people sometimes don't understand what the tools are. And you'll see I've said, for example, Butterworth, Juta, etc. Those are the first element in terms of your tools of your trade. And if you do not know how to use these products, or if you do not use these products, you cannot progress. It's like a person, and we're using the analogy of a marathon. If you do not have the right shoes, you do not have the right material or the running gear, you are going to be compromised. So that's the first aspect, is that know how to use your Butterworths, know how to use your Juta. You don't have to purchase them. There are libraries that are available, and I understand that at various chambers, these are made available for junior members particularly. And as you progress, you obviously are able to afford it on your own, and you need to do that. You need to purchase those. Then how are you going to produce your documents? And these are things that people don't think of. For example, am I going to be dictating? Am I going to be typing? What is the difference? What is my cost structure? How am I going to work this in order to produce a good-looking document with good content for my attorneys? And you need to find out, do I need a dictaphone, for example, or am I going to be typing it myself? And therefore, I need to ensure that I am able to do this timelessly, and that I do know, for example, how to format a document. So typing is one thing, but if the format is not right, you're going to embarrass yourself, and you're going to embarrass your attorney. So that leads on to the next portion, is produce a professional product. And you need to produce a professional product. Whatever goes out is an indication of what you are, and you're producing that to the world. And also know the rules, the practice manual. So if you are advising your attorney, advising your clients, you proceed from the basis of the rules and the practice manuals. In this case, for example, the Joburg Bar has got a very nice site. If you want to see a matter is on the roll, don't tell the attorney, it's very difficult for me to get this. I don't know where to get it. Go and do the research, find out and interact and produce a professional product, so that when your attorney contacts you, he says, this counsel provides a very good service, and I would go back to him without hesitation. Then communicate with the instructing attorney. So when you get the brief, acknowledge receipt of the brief. Many people don't do this at all. Request further instructions. If you're not sure, that would mean that you'd have to read your brief, and not just leave your brief and say, okay, I've received the brief, thank you very much. Read through the brief and then contact your attorney. There may be, for example, documents missing in your brief, and the attorney assumes that all the pages have been given to you. But if you read through it, you're able to tell the attorney, page 17 of mine is missing. I can't read the full contract, and therefore, and that might be a very important page that is left out. So communicate with your instructing attorney and advise your attorney if there's going to be a delay. For example, if you promise the attorney a memorandum by tomorrow, let's say that's Friday, and you're unable to meet the deadline, pick up the phone. Don't leave it for the attorney to keep on phoning you and then either not answering the phone, or you answer the phone, but you tell the attorney, okay, don't worry, it's coming, I'm just waiting. I'm trying to get my typist to do it on time. I'm doing X, Y, and Z. Be proactive. Contact your attorney and tell your attorney, I've run into problems. I can't get it to you by tomorrow. Is it okay if I get it to you over the weekend, or is it okay if I get it to you on Monday? And you must, before you make that call, know what your parameters are so that when you give an undertaking, you keep to it. And then give proper advice. This is very important. People are afraid of losing briefs. So some people would give advice that will prolong the matter and will keep the matter on the burner, as it were. If you, even at the risk of losing the brief, you will get others. If your attorney is confident, this is a counsel I can go to who will tell me, listen, we don't have a case here. Let's not pursue it, and wants to now speak to the client and consult with, in my presence with the client. But he's telling me things that I understand, because remember, attorneys themselves are legally trained, and they will possibly know, they will most probably know that this case is not a good case. And if it's coming from counsel and it fortifies what they are thinking and what their research has shown them, they will say the next time, we've got a difficult matter here, we've got a huge matter, send it to this counsel, because that counsel understands the law and is able to apply it and is upfront and gives proper advice. Be ethical, very important. Things, our professions and our lives are, sort of like a boomerang, and you will get things coming back. But just for your own sake, be ethical, be upfront, be open, be honest. Those are important things. Be collegial on a professional basis. So do not create fights and do not burn bridges between yourself and your colleagues, because you may, even if you don't require their assistance at any stage, it is just a good rule of thumb that if you are practicing within a professional environment, that you behave professionally, even if you find the opposite party behaving in a very unprofessional manner. So these are professional services, and that's crucial that we do that. What about the business component, the second component? The business component is there, again, there are a few components to this. The first element is that you price your services according to market standards. So find out what juniors of your category are charging. And if you have a specialty, obviously you fall into a different category because your specialty, for example, if you've been specializing in a field for about 10 to 15 years and you come to the bar, you're not going to start off at a junior's rate, and you're going to be starting off with certain work, and in terms of a specialty, at possibly a counsel who's there for 10 to 15 years. So just understand how you price your services. Don't undercut yourself and don't overprice yourself. And the second one, that leads to be aware of your costing. And this is very important. And when I say be aware of your costing, that is, how much does it cost for you to run your practice? Do you actually know? So sit down with a pen and paper, work out what it costs you, and you can do this exercise on an annual basis, because you have rental increases on an annual basis, you have price increases on different aspects. And from that costing, you will be able to see how much your hourly and daily charges would be and how they would be affected. If your costing goes up by 5%, you can increase yours by 5%. Your costing, if it goes up by 10%, and also be aware of inflation. But also be very, very acutely aware of how this business is going to come out and how it's going to be costed by you. At the end of the day, apart from your just running your practice and paying for your practice and maybe your car that you've now acquired, you also have household expenses. Now, you need to find a balance as to how you're going to work out that costing, whether some of it is going to be initially subsidized from a different source or whether you're going to be charging for everything. And if you are, what is it that you actually require? So let's just take an example. You need 20,000 Rand a month. So from there, you will be able to work out how much you need to work in the month, how many hours you have to bill, how many days you'll have to bill, and that is for perhaps just say all your expenses included. But if you have to look at your chamber's expense, might be 10,000 Rand, and that might include your, things like, apart from your rental and what have we, you may want to look at your typing costs, you may want to look at additional aspects, you may want to even include your car into that as a business expense, and then for you to look out and see how much you need to earn and whether you've got that capacity. And then charge for actual work done. And this is, I cannot overemphasize this. There are sometimes people and juniors who come into a brief, and even if it's a senior brief, they suddenly start just, work for 1 or 2 hours in the day and then charge a day's fee. And look at the actual work you do, write it out, time yourself, keep a clock running, and charge your client. And that's also part of being honest, because if you go and charge fees for which you are not working, but there is a balance. So sometimes it's a swings and roundabout policy. You will benefit if you book out a day. As counsel, you are allowed to charge for the day, and sometimes there's very little work that you do. You go in and the matter gets postponed, but you're still allowed to charge for your day. That is within the rules, so know your rule book as far as charging is concerned. Market your services through your work, and it's clear what work you put in represents who you are out there. Your attorney will see your work, your clients will see your work, you will see what comes out and what you produce in terms of your work. And that is a good indication and a good marketing strategy. You will pick up, as you go through your career, people on the opposite side who will say, I want that counsel in my corner. And there you will pick up a client from the opposite side who will go to the attorney and says to the attorney, remember that person who opposed us, that counsel, why don't we get that counsel involved? And then be clear as to your parameters of your financial engagement. I see there is a spelling mistake, and my costing is also got a 9 in front of it. Sorry, apologies for that. Financial engagement and costing to client, cost benefit analysis weighing up. So for example, a client comes to you and says through the attorney, we need you to fight this case for us. And the case is, say, worth 100,000 or 200,000, and you say, okay, we're going to do that. You need to be able to look at the entire case, and you need to assess the case for the client. If the client says, how much is it going to cost you? You can't go and simply say to the client, well, I think it'll cost you 20 or 30,000 Rand. Firstly, you don't do that. You don't tell the client if you are telling the attorney. And then suddenly, as the matter goes on, the client starts finding more and more money is being eaten away from the capital sum that the client wants to claim. And before you know it, your fees and your fees now exceed the capital sum. So you need to do that sort of cost-benefit analysis and be upfront. And if you don't know, you simply tell the client that I think that from my this 200,000 Rand will get caught up in costs. And where you will, your client might say, okay, thank you for being honest. Well, it might not tell you, but might think it. And the client will possibly tell you, okay, proceed with the matter. I want to fight this matter. I don't care about the cost. And then you know at least you've given proper advice. But you normally will get into quite a spot of bother if you are to start a matter, not work out the cost-benefit analysis for a client, and then it creeps up, and eventually client says it was not worth fighting this fight, and then disputes your fees as well. And then the other aspect is what we discussed right at the top. Be price competitive and be very aware of that aspect as well. Then the last aspect is the individual person component. So you are the trunk of the tree. All your work and all whatever you produce are the branches. You need to make sure that you as an individual are strong in every sense, and that you keep on building. Remember, we said it's a marathon, so you're not expected to know everything right at the outset, and don't put that sort of pressure on yourself. It's unfair to yourself. Know that it is a learning process, but as you learn, chalk it up and work out ways of remembering things and of developing. Then remember that your practice is based on you. So you have to take care of yourself. Take time for yourself in order to rest, develop your personal life, your health, look after it, live within your means. It's no use if you're earning an amount of 20 or 30,000 Rand a month that you go out initially and say, okay, I'm going to buy a sports car, and your monthly repayments of that are over 20,000 Rand, and you're living off 3,000 Rand or 5,000 that you have as a balance. And then you struggle to pay your rental at Chambers, which is your primary source of income. So your main source of income, you're now compromising, and you're doing that because you're living beyond your means. Develop yourself by reading, your hobbies, your time. So spend time, take time off, develop yourself, and this component is important. So those are the three components that you need to take care of, and it's crucial. And then in conclusion, I say, remember that building a practice is a marathon, not a sprint. And that's the end of the show. So if you can go with something, if you haven't taken anything else, then just remember this very, very important thing, that building a practice is a marathon. That's the end of the slideshow, people.
Thank you so much, Aslam. Thank you so much for that. There's a question from Patel, Advocate Patel. You can simply, I'm just going to allow for question and answer session. Just give me 1 second so I can enable it. Okay, Advocate Patel, you can simply unmute your mic and your camera. Okay, all the participants, by way of a reminder, all the participants now is the time I've opened a question and answer session, so you can simply just raise your hand using the Microsoft Teams platform should you have any questions. I see there's a question from Advocate Patel, but I think he's having a network issue. Let's just bear with it. Sorry about it, Islam. I think Mohammed is having a difficulty. I think I'll ask the first question. Advocate Bava, tell me, in terms of, I see you put a lot of emphasis on obviously on your savings and working out your budget and all of that pertaining to your practice, and that is indeed important. Now, naturally, when we get, you started off the presentation with that building, and I humbly say that you are up there, and by means of that, 45% of your income goes for tax purposes. How do you manage that, Advocate Baba?
Okay, so the very important question as far as looking at aspects relating to tax. And if you earn at certain brackets, you obviously start paying, and then the upper level would be 45%. The issue is, I always say, make the money first and then worry about your taxes. And when you're making your money, you will find that you are able to afford good advisors who are able to tell you in a very legitimate sense and very honest sense what expenses you can actually include that will now allow you to facilitate your practice, and which will work out as a tax deduction. So as opposed to paying everything to the receiver gives you a benefit to say that if there are any elements or any machinery or what have we that you are using in the generation of your income, that means those are your tools. So for example, your Butterworths, your Jassat, aspects such as those are tools of the trade which you are allowed to deduct. So there will be a certain level, and I also want to emphasize that make sure that you register for tax and make sure you pay your tax. People often get too afraid that the receiver is going to take a lot of money, and they try and get away from this before even earning a single cent. So get away from that fear about what the receiver is going to do. I always look at the level at which I see an initial tax amount from my accountants to see the level of progress that I have done from year to year. So it's a very good indication for me. It's not something that everybody wants to pay, but remember, you are paying for facilities that you use ultimately. So it is a managing process as far as that is concerned, but it is also one that you shouldn't put the cart before the horse. Earn the money first, and then once you have earned the money, sit with an advisor who will be able to advise you on the legal requirements of what deductions can be applied.
That answers the question perfectly. Thank you so much. There's a question from Advocate Patel. Advocate Patel, you can simply unmute your mic and your camera.
Assalamu alaikum, Advocate Bava. Maaf, I was having some network issues earlier.
Okay,
firstly, thank you for availing yourself today and assisting us. I believe every single individual here in attendance has gained a plethora of information, and we thank you for that. The question, I have two questions. The first question is really in relation to building your practice. Now, with the onset of the COVID pandemic, as a junior, I think we're finding it very difficult in reaching out to attorneys and letting attorneys brief us. I mean, pre-COVID, I mean, by an attorney seeing you in court, you could actually interact with an attorney and with the hope of eventually getting a brief. But now, with all matters being heard online, it's only mainly the counsel that are actually joining in, and your interactions is limited to the counsel and to the presiding judge. So, what recommendations would you have to juniors to actually put their names out there and to get attorneys briefing you? That's the first question. And the second question I have is in respect of sending out, making phone calls and sending of emails. Many juniors are using Gmail accounts and are using Yahoo accounts. Would you recommend us moving into a more professional domain, such as an RSA bar domain or an MWeb domain or something along those lines? Thank you.
Thank you very much, Mohammed. Firstly, it's my absolute pleasure for being and my honor to be part of a process where we all try and assist each other and build each other. Coming to the first element, as far as COVID is concerned and as far as junior practices are concerned, it is a huge challenge. The ball game has changed, and we need to find ways of adapting to that. You are correct that normally what used to happen is you used to walk into court and an attorney would meet you at court, find out who you are, listen to your presentation, and from there decide whether they want to brief you and then follow up and brief you. And that led to a lot of extra work or a lot of work, and that led to building of practices. Remember, the fundamental aspect on practice in the first session that we did is build up relationships. Now, what you need to do, as the way I would look at it, is that you have got enough junior members to be able to say that the terrain has changed. How do we adapt? Do we now start setting up meetings between counsel and attorneys as introductory basis in order for attorneys to get to know counsel, for counsel to get to know attorneys? So in this age where we are now sitting with completely video conferencing platforms, I think as juniors need to try and see if there is a way that you can all get together work out a strategy and start implementing, very similar to what you've got in terms of the training. You could start having, for example, weekly sessions with different law firms, introducing your members, getting them to introduce themselves, the attorneys, finding that there are synergies in terms of different areas of the law that they can start talking to you about in terms of exchanging of briefs, or at the very least where they may need assistance or their clients. So many times what happens is that attorneys would say that we do not have a junior counsel to brief because we don't know who they are. So they will stick to people they know, or perhaps try and do it themselves. I think this element is one that you need to start looking at in terms of creating an environment. Sorry, your second question was, I've forgotten your second. I was concentrating on the first. Sorry, Mohammed.
Yes. Sorry. His second question was pertaining to an email domain. Would that make any?
Yeah. So professionally, there is the very it's the projection that you have in terms of marketing. So the ideal situation is to have an email domain that reflects your practice and where you are practicing from, almost as though you were a firm of attorneys or you were corporate. So, if you look at any of the big corporates, or you look at any of the big firms of attorneys, you will find that their email addresses are linked to the name that they want to project. So I think that would be advisable as you are developing. But as you go along and your attorneys get to know who you are, that spreads a bit. You can then get a Gmail address, but it would be better to create a domain name and a domain email for all your people in your group here.
Thank you so much, Aslam. Aslam, sorry, just to build on Mohammed's question. Now, I want to bring up something that one of our members had an issue with, and that was with regards to touting. Now, can you give us, or rather, can you explain more with regards to touting in lieu of such? And I'll give you an example. One of the members simply sent out an email to another attorney, and introducing himself, and after that he got an email from another advocate saying that that's touting. Now, in line of what you said and in line of Mohammed's question, what did you regard as touting, and how do we overcome that?
Sure, Ahmed, I'll look at that. I see there's two hands that have been up for a while, and one is Matsuiki Tapelo, and the other one is Motebang Ramaidi.
Sure.
Yes. So as far as touting is concerned, the Bar Council rules are that we should not be touting, and there's a very thin line. So the first element I would say is that when you get into practice and when you are practicing, nothing precludes you from phoning all your university and school friends and tell them I've started practicing. That's not touting. That is telling them where you are. And that too is an advertisement in a sense, but it's not precluded in terms of the rules from my understanding. What would be is, for example, you send out emails and say, I offer these services. If you want to know more about my services, please contact me. And I am an expert in doing commercial litigation, and I've appeared in these constitutional court cases. All of that would constitute touting. But taking it within its context as well, if, for example, you're doing work for an attorney and the attorney says, Aslam, please keep me informed of what you do. And the attorney knows me quite well, to send an attorney an email saying, I appeared in a case last week and we had this fantastic result in X, Y, and Z. That does not constitute touting. That is communication. So just be aware of the parameters of what constitutes touting, because touting is not allowed in terms of our rules.
Thank you so much. That answers the question. There's a question from Tapelo. Tapelo, you can simply unmute your mic and your video.
Good afternoon, Advocate. I hope you can hear me.
I can hear you.
My name is Thapelo Matsuki. I'm still a pupil. So I wanted to know with regards to specialization, if I'm still new, I haven't practiced law, would you advise someone like me to have a specialization or to just take briefs as they come?
I would strongly suggest that you do as much general work as possible. I just give you, and I always give this example. The reason for that is that when you enter an area of specialization, it comes along, if you're just starting your practice, you will not have opportunities to go into a specialized area. Because firstly, the attorneys firms in giving specialized type of work will look for people who have experience of that specialization. So it's a catch-22. But let's look at the general proposition of why you need to do as much general work as possible. Let's assume you advising a person in terms of labor law. And in labor law, you're telling this company, okay, you owe these workers so much money, but we need to get, and your client says, get me out of this. I don't want to pay this huge amount in terms of the severance packages. I want you to get me out. And you write out a letter and you say, my client, which is company X, cannot afford to pay these amounts, and therefore these amounts are not going to be paid to you. Now, what happens is that automatically invokes a provision in terms of the Insolvency Act. And the trade union that may be representing the workers might just decide that they're now going to bring an application to liquidate your client as a company. So the interrelationship between what you're doing becomes very crucial. And if you start doing general practice in every area, you start becoming aware of different areas of the law. Because remember, as many years as I've practiced, I still read, and when I look at a case and I look at the reasoning and I look at new aspects of the law developing, I am still learning. And that's one of the beauties of our profession, is that it's a never-ending learning process. And if you enjoy learning, then it's fantastic. It's hard work. Let's not fool ourselves. It's very hard work. It's stressful, and that's why the balance is crucial for us. But it's also very rewarding. So I would go into a general, do anything, whatever comes my way. If it's a divorce matter, if it is a labor matter, if it is whatever it is, a lease matter, do it all.
Thank you so much, Aslam. There's a question from your colleague, Advocate Motebang Ramaili. Advocate Motebang, you can just unmute your mic and your camera, please.
Yes, Asi.
Hello, Motebang.
Afternoon again. That's the question that I was going to ask, but the question that I wanted to ask you, like I'm saying now, the times are, I know you're one person who believes in technology and moving with times. Now, traditional, I'm one of those people who still believes in occupying of the chambers, and, chambers create a community for our own people. So what would be your view in light of this movement of people moving towards formation of the visual offices in light with the traditions that are usually created historically by a community of advocates in the bar or within the groups? So that's what I wanted to ask you about it, because you see, I'm one of those people who still believe traditionally of occupation of the chambers, but now people are moving towards the visual chambers and moving with time. So I just wanted to hear your view in light of those things that are currently happening. That's my question.
Yeah. So as much as I like technology and I like being up to speed with technology, I also am of the view that occupying chambers is crucial. It's crucial for a number of reasons. Firstly, there is the exchange between colleagues. If you are doing a matter and you knock on a colleague's door to talk to them about the matter and bounce an idea off them and find out about the latest law, after having read yourself. And it's very important that we understand that always try and do the work first yourself, very hard. But this community that we build is very important in the sense that it allows you a platform, it allows you a base, it allows attorneys to interact with you. Now, yes, we do have this, if we can call it a hiatus, where we're sitting with, and it might become, in certain senses, a very convenient way, where you don't need to go and attend a consultation. But I think that gathering together at chambers, getting to know each other, your attorneys coming to chambers, you create an environment that will allow all the members in the group to progress. Let us look at the situation. Let's say the COVID pandemic now comes to an end, and everybody starts going back to chambers after a year or two. If you don't have the intention and you still want to stay on your on your computer, I think you'll miss out on a lot of aspects. I think that you will not be able to create more business links, and I think it will become detrimental to your business. Yes, if you've got a very established practice and people come to you as opposed to you wanting work from other attorneys, then it might be different. So certain specialists, to them, they may be able to just sit at home and work through it. But I think that having chambers and continuing in that vein is crucial and fundamental.
Thanks a lot.
Thank you so much, Advocate. Advocate Bava, there are a number of other questions from the participants. However, time does not permit for such, and regrettably, I have closed the question and answer session. Furthermore, I am fasting, and the Muslim community is fasting today, and it's about to be sunset very soon. So regrettably, once again, I have closed the question and answer session in lieu of such. What remains? On behalf of the South African Bar Association, we sincerely thank Advocate Bava for his inspiring address and his time and foresee working closely together with him in the future. Appreciation to all those that have participated virtually and shall be watching this session at their leisure. These sessions are recorded, and the recordings can be found upon the South African Bar Association website, that being www.rsabar.net. I thank you.
Thank you very much.
Thank you.
Thank you, Council.
Thank you.